Thank you for joining us today for our webinar on custody mediation and domestic violence, what advocates should know. My name is Melissa Mangiaracina, and I'm a part-time program attorney at the National Council of Juvenile and Family Court Judges. At the Council, I work pretty exclusively in our Resource Center on Domestic Violence, Child Protection, and Custody, where we prepare resources and provide technical assistance and training for professionals and survivors at the intersection of domestic violence and child protection and the intersection of domestic violence and custody cases. Before coming to the Council, I worked as a child advocate attorney in the Reno area for about 10 years. I represented children in child maltreatment cases, also known as dependency cases, and custody cases. I worked for an attorney for legal services during that time, and then I came to the Council. And for the past 5 years or so, I've also worked as a pro tem or substitute judge, where I put on a black robe and tell other people what I believe is best for them. So while I absolutely recognize the value of our judicial system and the importance, especially in cases involving family violence, I decided to become a mediator because I realized that I really prefer to help families reach their own solutions when they're able to do so safely and in a mutually beneficial way. I have a private practice in the Reno-Tahoe area, and I sit on our local court custody mediator panel and our statewide dependency mediator panel. While I absolutely love mediation when it works, I'm well aware of the dangers that it presents for families in cases involving domestic violence, for many reasons, including a lack of understanding of domestic violence by many mediators, the power differentials that can arise in cases involving domestic violence, and the nature of the domestic violence itself. For this reason, and because we recognize at the Resource Center on Domestic Violence, Child Protection, and Custody that the use of mediation in custody cases is continuing to grow rapidly, we've decided to focus some of our time and effort this year on creating publications and resources related to custody mediation and domestic violence. So this webinar is one part of that effort, and we're incredibly grateful to have Janice Garceau here with us today to help me present this information for you. Since I will not be able to do justice to Janice's incredible experience, I'm going to let Janice go ahead and introduce herself before we get started.
Greetings, participants. My name is Janice Garceau. I'm a licensed clinical social worker in Oregon, and I have been practicing in a number of arenas for close to 30 years. The first 10 years of my career, I provided direct services and clinical supervision in a family violence treatment program where we provided services to both children and adults who had been victims and or offenders of physical or sexual abuse. So that included quite a bit of work with domestic violence survivors and also with domestic violence offenders in a number of contexts, as well as involvements with the courts for child dependency in criminal matters. Subsequent to that, I came to Oregon and began working in the field of mediation. I ran 2 domestic relations court-connected mediation programs, so those are programs that operate in Oregon out of county settings and provide mediation to individuals that have been mandated to mediate because of disputes about custody and parenting time. During the course of that time, I also conducted numerous custody and parenting time evaluations and briefly ran a supervised visitation and safe exchange program for families impacted by domestic violence through a Department of Justice grant. In those contexts, I relied very heavily on my mental health background in terms of understanding conflict in relationships, the needs of children, how domestic violence manifests in disputes in families, and other things of that nature. I also had the opportunity to become aware of the difficulties that domestic violence survivors encountered when they were navigating domestic relations or child custody proceedings. And as a result of that, I did some work both at the state and at the national level on grant applications and court enhancement projects focused on improving responses to domestic violence survivors navigating courts. I am now back in the field of mental health. I manage outpatient programs and a mediation program in Bend, Oregon, and have done so for the last 3 years. so I'm very much immersed again in working with families and children and adults who are struggling both with trauma, with violence, and with mental health disorders. Thank you.
Thank you, Janice. Okay. Sorry, 1 second, I'm having, there we go. Okay, got it to work. As I mentioned in my introduction, this webinar is one of a part of a greater effort to address custody mediation in cases involving domestic violence. At the Resource Center, we strive to provide resources and technical assistance to both professionals and survivors and in the areas of child protection and custody cases. So we've created today's webinar with the intent of helping advocates better understand what custody mediation entails, identify concerns that might arise when mediating custody cases involving domestic violence, and recognize ways that advocates can help survivors prepare for custody mediation. Although this webinar is designed for an audience of advocates, we of course welcome any and all professionals, survivors, or any other individuals that have joined us today and are interested in learning more about this very important topic. So before we move on, we'd like to get a sense of who's with us today. If you can please click whatever your profession is, if it is represented in this poll, and if not, just click Mediate or click Other and maybe share in the chat box what your profession is. So we'll take about 20 more seconds to have you go ahead and click your profession if you have not done so already. Okay, thank you. So it looks like the vast majority of you are, in fact, domestic violence advocates, but I'm also really happy to see that we have some attorneys, some mediators, some victims advocates, court coordinators, mental health professionals, child support workers, CASA, it looks like. So this is great because we've really prepared this webinar in a way that will hopefully provide helpful information to all of you in all of your various professions. While the focus is on how advocates can help prepare survivors for custody mediation, many of you are advocates in many different senses of the word, so I think it will be hopefully helpful to all of you. So this webinar is actually one of a series of webinars and publications that we're working on that focuses on helping self-represented litigants. This project really came out of the realization at the Resource Center on Domestic Violence, Child Protection, and Custody that many, many survivors are unrepresented in custody cases. And as we know, this can be incredibly dangerous and problematic in cases involving domestic violence. So at the Resource Center, we host an 800 line, and what we found is that the vast majority of our callers are self-represented litigant survivors who cannot afford or find an attorney and who really are seeking help and resources for their custody cases. So when we looked at these numbers, we realized that we needed to start thinking about innovative ways that we can help inform survivors. And one of the ways that we found that we can do that is by helping educate and inform advocates so that they can help survivors prepare for their court proceedings, how to present evidence, and other topics that they might face in their custody case. So needless to say, custody mediation popped up as an area that we probably wanted to take a look at. So although we were pretty sure that what we were seeing on our 800 line was reflective of the norm across the country, a quick look at some of the data helps explain why it's so important that we at the Resource Center and you as advocates find ways to help prepare self-represented litigants for custody cases. It's become quite clear that the lack of legal representation is probably not going to go away anytime soon. And as you can see on this slide, 70 to 85% of litigants in family court are self-represented. We know from the research that this is not a choice that litigants are making, but rather that they're finding that they either cannot afford a private attorney or that there are insufficient funds and resources at their local legal aid to provide attorneys for every litigant. So to shed some light on just how bad this crisis really is, a 2016 article entitled Future of Legal Services in the United States quoted an economist for saying that each year, United States lawyers would have to increase their pro bono efforts to over 900 hours each to provide some measure of assistance to all households with legal needs. So when I first heard this number, I took out my calculator and I did the math to try to see how many hours per week this would work out to. And what I found was that this would require every attorney in the United States to offer over 17 hours per week of pro bono assistance or free legal assistance. As a legal services attorney for a decade who worked incredibly long hours for pretty minimal pay, this realization was really quite tragic for me. It's not sustainable, it's not attainable, and it's really, really unfortunate. So to take things a step further, we know that the incidence of intimate partner violence in this country is incredibly high, with 1 in 3 women and 1 in 4 men experiencing domestic violence. We know that when we look at divorce cases, domestic violence is present in over half of them. And at least one study revealed that domestic violence might be present in up to 75% of disputed custody cases. So when you take all of this data and you put these numbers together, it becomes pretty quickly clear that an incredibly high number of families that are experiencing violence are having to navigate custody cases without the assistance of an attorney, and often without really understanding the long-term safety and other implications of what might come out of their custody case. So for this reason, at the Resource Center on Domestic Violence, Child Protection, and Custody, we've embarked on a large project to create guides for self-represented litigants that have experienced family violence that help walk them through some of the challenges of navigating a custody case. So you can see on our screen that to date we have published 4 different publications that are all available on our website. And that website address is there on your screen, www.rcdvcpc.org. So these publications that have already been completed and are already available include 10 steps for presenting evidence in court, 10 ways to find help with your court case, 10 things to know about family court, and how to gather technology abuse evidence for court. The first 3 of these documents are also available on our website in Spanish, and any of these documents can be printed from our website, or you can request a printed copy that we can mail to you through our website. In order to access these on our website, simply go to the website, click on our resources drop list, and select publications. So in addition to each of these publications, we've also developed webinars like the one that we're holding today for advocates on each of these topics. Those webinars are also available on our website or upon request, and they have been designed to help advocates understand the information that we've put into our Self-Represented Litigant Series publications so that you as advocates can help survivors navigate the process. I like to look at these webinars as embracing the concept of sort of training the trainers, where we help you understand the content that we cover in these publications so that you can help survivors that you work with better prepare for and understand their custody cases. I'm happy to report that we're in the very final stages of preparing a similar publication for self-represented litigants on custody mediation and domestic violence, and that the PDF should be available on our website by the end of this year. We will also have paper copies printed and available in 2019 at some point. And when you signed up for the webinar today, if you clicked the option of receiving notifications from the Council and from the Resource Center, then you'll receive an email that lets you know when these documents become available, and you'll be able to go to our website and download them. If you did not click that link and you'd like to receive notifications when these publications come out, you can go ahead and let us know in the chat box or by sending me an email at the end of this webinar, and my email information will be available on our last slide. So without further ado, I'd like to pass the torch over to Janice now and let her talk about custody mediation and what it entails.
Thank you, Melissa. So I want to start by just creating a little bit of understanding of the field of mediation and some of the principles and the philosophy out of which it operates, because I think that's very important for advocates to understand. Alternative dispute resolution, which is the larger field that contains child custody mediation, small claims mediation, lots of different kinds of mediation in civil cases. Alternative dispute resolution has probably been around for close to 40 years now as an emerging field. And it's started out from a very purist perspective, and that perspective was that individuals are better suited to derive solutions together in a collaborative process than may occur in a courtroom. So individuals that have been involved in a civil matter, like a landlord-tenant dispute or a dispute over custody, have lots and lots of ideas and thoughts about what may be best for them, and that those things are often better resolved in less formal settings, less adversarial settings that allow for flexibility, for creativity, and for the individuals involved to really be connected to the outcome and feel responsible for it. So that's kind of the ideal world. Some of the core tenets of mediation are that mediators don't decide cases, and they don't classically give advice. Doesn't mean it never happens, but in the tradition of the field, that is not seen as pure mediation. Mediators are really there to be facilitators of a process, referees of a process at times that allow people to work towards agreement. Another core tenet of mediation is that the mediator really remains neutral and impartial. So they work very hard, and often their training is very focused on maintaining a position of safe neutrality so that individuals don't feel that someone is taking the side of one person or the other. And that's really because people come to the table with very strong feelings about positions, and if you're going to facilitate a process, neutrality becomes very important. Another core tenet, often embedded actually in statute or local rules, is that this is an absolutely private process. Part of the appeal of mediation for many participants is that unlike a court setting where there can be people in the courtroom that are not known to the litigants, where there's a court record that's being created, mediation is protected very strongly in terms of confidentiality. So typically, in most jurisdictions, things that are shared in mediation cannot be shared outside of mediation, and that really is to protect the integrity of the process. Mediation is often voluntary, not always. So every jurisdiction really handles the voluntary nature of mediation differently, and that can be anything from an opt-in program, you can mediate if you choose, to you are required to be informed of your option to mediate but not to actually attempt to negotiate, or communities that actually require at least one face-to-face or some sort of in-person mediation appointment. Mediation is based on the notion that decision-making and problem-solving should be collaborative. So there is a lot that's done in classic mediation that comes out of the notion that two individuals can collaborate together to solve a problem that is of mutual interest to them. And that concept of collaboration is something to hang on to as we go through this webinar. And finally, ideally, mediation should be safe. So the mediator's role when they're in their wearing their referee hat is really to make sure that people are engaging in a good faith effort to reach agreement and using respectful language and demeanor in the room. And again, there's great variation in the degree to which mediators are enforcing anything from neutrality to the safety of mediation. Ideally, what is custody mediation? It was intended to give parents an opportunity to make their own decisions about time and access to children and decision-making about children. There's been a long-standing recognition that often courts, the formality of courts, the busyness of courts can make it not the ideal place to make nuanced, individualized decisions about plans for children. The hope is that mediation allows for a wider array of options for parents. It really allows a place for parents to be creative in formulating plans, coming up with solutions on their own that are much more difficult to come up with in a courtroom or impose arbitrarily out of a set of rules. Mediation typically incorporates the notion of keeping the child's best interests at the heart of the negotiation process. So most mediators who are doing child custody mediation are trained to think about, to represent, to bring the interests of the child always into the conversation. So you will find, if you ever have the chance to observe a mediation, that mediators are often helping parents focus back on the needs of children and not on the historical conflicts or disagreements that may not directly relate to caring for children. Mediation may not address other issues such as child support or asset distribution, or it may. Typically, private mediators are more likely to deal with the financial issues that come up in a divorce or a separation than some of the court-connected or publicly funded mediation programs. That is not always true. There are certainly county or publicly funded mediation programs that deal at a minimum with child support issues. So that really varies across states and is dependent on resources. So what is not always ideal about mediation? Training for mediation is, while there is a strong core set of philosophies, there is a broad range of training available to mediators. There are different rules in different states and different communities about the level of training a mediator should have, anything from very minimal requirements to fairly rigorous requirements around having advanced mediation training and training in child development, family violence, and substance abuse and those kinds of issues. So while there are some very broad general principles, that does not always mean that mediators in any given community are adhering to all of those. Some mediators will give advice to a party about the merits of an offer or may not do as good of a job holding the neutral, safe space for negotiation and communicate things with body language or tone that direct the mediation in one direction or the other. There are, in fact, some programs where mediators actually are in a recommending role. Some communities in California for a period of time had recommending mediation programs. Some mediation programs, and really many now, are requiring some level of involvement in the process. In many instances, there are some exemptions for cases involving domestic violence, but those exemptions often have to be requested from the court, and that process can be difficult for survivors to become aware of. In addition, often there are jurisdictions where the exemption only applies to people that have active protective orders, and for folks that have not necessarily accessed the courts or law enforcement for safety, that option may be less available to them. And again, as I mentioned earlier, some programs do request that the mediator report to the court. So in those instances, the confidentiality of the mediation process is a little bit different than it might be in other settings. Other limitations, the classic tradition of mediation considers it best to have both people participating in person in some way. And that has often meant historically that parents were expected to be in the same room with each other, typically without an attorney or support person present. And again, this can vary very broadly by jurisdiction, but classically mediation's expectation was that two individuals sat down in a room together with a mediator to have a face-to-face conversation, develop common interests, and flesh out their disagreements and come up with solutions together. Another factor is that many mediators have, at best, a very cursory understanding of domestic violence. So many mediation rules require that a mediator has some exposure to training in domestic violence, but often that is a domestic violence 101 sort of training. And it really doesn't go very deeply into things like the frequency with which contested custody cases have domestic violence contained. It may not go into, in any great depth, how coercive behaviors can impact a process that's supposed to be collaborative, and so on. So the level of training that mediators have regarding domestic violence and the impact post-separation is often pretty inadequate to the level of need that presents in mediation. And again, and this is the thought that I really wanted folks to flag as we headed into this training, mediation relies on and values collaboration. And in a domestic violence dynamic, coercion is present, as all of you know and you're experts on. And coercion really works under different operating principles than collaboration. Collaboration is really based on the notion that two people both come to the table with some inherent belief that each person's position and wishes and needs are valid and valuable, that each voice at the table should have equal weight, that there should be some fairness in decision-making. And what we find often in coercive relationships is that those values are not really embedded in the relationship. There is typically a person who believes that their needs and their wishes and their concerns are should carry more weight and are more important and more meaningful than the others. And so it really can be difficult to mediate in settings where there is domestic violence present for those reasons. So, that said, what I experienced in my work life as a mediator was that increasingly domestic violence survivors were requesting mediation and preferring mediation to court situations for many reasons. And I worked in one county where mediation was actually not allowed in cases where there was an active restraining order, and I worked in another county where it was allowed. And what I found is that in the county where mediation was not allowed, there were actually a much larger number of domestic violence survivors who reached out and asked to have that option available to them. As advocates probably know better than I do, domestic violence survivors have sometimes not experienced courts as safe places to address some of their concerns about their kids with a person who's harmed them, and they hoped for other ways to make decisions about their children that felt more within their control. So I'm just registering a question here. The question is, can you discuss the most effective way to train child custody mediators? We have a training and have included these aspects, but have been told that they run against the lived experience of mediators. I'm not sure about the second portion of that question, but I will get back to it before I finish, when I finish this slide, so just bear with me. Some concerns about mediating cases involving domestic violence. Obviously, these are relationships where there's been an unequal balance of power to bargain. There can be very acute active safety concerns, both about harm, physical harm coming to the person, or other abuse tactics being initiated during the mediation. Obviously, we've talked about the concern about mediators not being as familiar with domestic violence. And survivors may be intimidated into giving up important legal rights, which is an important piece to keep track of. Possible benefits: it's certainly more affordable than retaining an attorney and going to court. It can be empowering if the survivor is adequately prepared for mediation and is able to mediate in a safer setting and feels that they were able to accomplish some things they may not have been able to accomplish in a courtroom. And as we've all recognized at various points in our career, court processes can be very traumatizing, very intimidating, and quite adversarial. And we know that the likelihood of increased violence often escalates around the time of trials and court hearings. So mediation can have some benefits that are protective. In terms of the most effective way to train custody mediators, I found it very helpful to I think it's very helpful to employ mediators that really have done the work around domestic violence screening and have learned some things from that experience. So what we found is when we began to screen for domestic violence, we uncovered profoundly more domestic violence than we had seen before, and we really thought we were pretty on top of it. And as it turned out, until we implemented universal screening, we were not. So you would want to employ a mediator who is universally screening for domestic violence, which means they're seeing it a lot and they've probably got more experience. When I trained, I was able to train with advocates, so that balance of a mediator and an advocate is really helpful. It's certainly helpful if the mediator has some other kinds of professional experiences with families where domestic violence has occurred, because I found that knowledge of child experiences of violence in the home and survivor trauma and domestic violence offender dynamics to be incredibly helpful in understanding what I had in the room. Other aspects of training that are helpful are scenarios, lots of use of scenarios and letting people work through some of the difficult pieces that come when you screen for domestic violence and have conversations about creating more safety. So I would make sure that a training incorporates scenarios. And last, that it really highlights the different perspectives of a mediation community and an advocacy community and where some of the tension points may be and how to have those conversations. For example, the tension between a collaborative model and an advocacy community that really understands the coercive nature of domestic violence. The tension around, not necessarily between, but around privacy issues in mediation versus in court versus in advocacy programs. Many mediators are mandatory reporters. Many advocates are not. It's an important distinction for people to understand. So those are some of the things, and there's probably much more we could say about training, but those are some of the things I think would be key, that you're training on universal screening, that you're training on the differences between the philosophies, that there are scenarios that people can practice, and that you're really looking at the safer options for mediation and how to do those concretely in a technical setting. And I will turn things back over to Melissa.
Thank you, Janice. And on the topic of training, we do offer tailored trainings here at the Resource Center on Domestic Violence, Child Protection, and Custody. And so that is the type of thing that we are able to help prepare and or possibly provide. So you can certainly reach out to us if you would like to talk more about improving training in your local community, because you'll see later in our slides that's where this starts, right, is making sure that the mediators that are working on these cases really do understand domestic violence and the unique dynamics that come with it and how it really does impact custody cases in ways that they don't realize. despite their lived experience. So I think that was an excellent question, and yes, that's where it starts. And just to throw it out there, in addition to the self-represented litigant publication that we're finalizing right now, we're also finalizing a guide for mediators with links to the existing literature out there on sort of ways to approach domestic violence or custody mediation involving domestic violence. So that will also be available this year on our website. So we're going to move forward with a case scenario because, as Janice said, it's helpful to try to visualize actual cases. So I know that the writing is small, so I'm going to read through this. And as I do, if you will just sort of jot down concerns that come to mind when you think about this couple going into custody mediation. Don and Carissa have been married 8 years and have 2 young children. Carissa tells you that their early years were good, though Don was always jealous and controlling. She says their issues started when their youngest was born. She admits that she got real depressed and that Don became irritable and explosive at home. She says that he became paranoid, that she was seeing someone else, and she had to text him constantly. Carissa filed for divorce after Don threw a trash can at her in front of the kids, leading to a bloody cut on her forehead. Carissa and the children went to stay at her sister's house. She declined to get a restraining order, though police and family encouraged her to. Carissa has filed for divorce and is seeking custody of the boys. She's willing to share parenting time, but she wants the kids at home with her at night. She feels Don is too angry to put up with them for long periods. She also says that he's been harassing her. She reports that he's been asking their eldest child about her activities and whether any guys are coming around. She says her oldest child is getting anxious at bedtime, which she attributes to his worries about the divorce and his dad getting mad at him. Don's responsive pleadings also requested custody of the children. In them, he says Carissa is unstable. He points to her postpartum depression and says she's always had low self-esteem. He says she has a history of being sexually traumatized as a child. He feels she'll make bad choices about men and is not a stable parent. The parents were ordered by the court to attend custody mediation. So what concerns come to mind when you hear this case scenario? I saw that a lot of good notes were added to the chat box. So here are some of the ones that came to mind when I look at this case scenario. First, I'd be very concerned about Carissa's safety, both physical and emotional. We know from the facts that Don can be controlling and explosive. We know he can get paranoid and that he's required Carissa to text him constantly. We also know that he can get angry and has physically assaulted her. Based on this, I would want to make sure that Carissa is not set up in mediation to feel unsafe in Don's presence. Next, as a mediator and advocate, I would want to make sure that the safety of the children, also both physical and emotional, is addressed in the custody mediation. The facts indicate that Don gets mad at the children and that the eldest child is feeling anxious. Carissa has indicated that Don may not have a lot of patience with the children, which is important when looking at a safe custody arrangement long term. I would also take note of Don's harassing texts and contact with Carissa. So if the parents were to enter into a sort of joint custody agreement or even grant Don parenting time, they will have to communicate with one another somehow. So I would want to start thinking about what that communication should look like and how it would be possible to keep Carissa safe. I would note Don's practice of involving the children in the parents' conflict by asking the children about Carissa and whether she has any guys coming around. I would worry in this case that Don would continue to harass and control Carissa through the children. Given Carissa's statements about how controlling and paranoid Don can be, I would also worry that Don would not be able to work cooperatively at mediation and that he will instead attempt to use the process to continue to assert his power over Carissa and control her. I would worry that the mediator may not understand domestic violence fully and that the mediator might be unable to identify a power differential in the room or have the tools needed to keep a balance of power. In addition, I would be concerned that Don might use his statements about Carissa's instability, depression, and alleged sexual traumatization, if that's a word, as a child against her in the mediation. So we know that many mediators do not understand the dynamics of domestic violence, and that batterers can be very skilled at making their partners appear emotionally unstable and unable to care for the children. So I would worry right away that this would be a problem at mediation. And finally, I would be really concerned that Carissa's desire to have the boys stay with her at night would be misinterpreted by the mediator as her acting as rigid. So in the field, we've all heard people use the term gatekeeping for parents that they perceive to be unwilling to work together. But we know in the field of domestic violence that most often this is actually protective parenting, just like in Carissa's case, that her desire to have the boys with her is actually a desire to keep them safe. But I would worry that if a mediator did not understand domestic violence or have adequate training, then that could be used against her in the mediation.
Can I jump in, Melissa?
Yes, please.
Yeah, that last point about gatekeeping is really a critical one, and it's one where I often saw this disconnect between the domestic relations community and the advocacy community. As advocates know very well, domestic violence survivors who do not do all sorts of things to, quote, protect their children are really seen in a punitive light and often with a great deal of judgment in lots of systems. And the absolute opposite of that is true. Divorcing parents who make it difficult for the other parent to have contact with the child are seen in a very negative light often and are experiencing a lot of judgment and sometimes even consequences for the court. And I found that to be one of the most difficult dilemmas for domestic violence survivors is in one setting you are expected to take all sorts of steps to protect your kids, often at the expense of your own safety. And in another setting, you're penalized for those very same steps. And so that really is a dilemma as we're coaching folks who are dealing with these situations about how to navigate those two very different systems and philosophies.
Thanks, Janice.
Yeah.
Okay, so here's another interactive question for you. What should the custody mediator do to account for Carissa's safety and meaningful participation? You should be able to click any that you think apply. Oh, so it looks like you're not able to click more than one. If folks are running into that, then click the one that you think is most important, perhaps. Are others having that problem? Okay. Okay, thank you. So I see that the vast majority of you have selected determine whether it's safe and appropriate to mediate, and I think that goes hand in hand with number 2, which is screen for domestic violence. And those are absolutely essential, really, in every case involving domestic violence. And so we're going to talk a little bit about what we can expect mediators to do in every case that involves domestic violence or potentially involves domestic violence. But again, we're talking about the ideal. We're talking about the best case scenario. So remember when I referred to this as sort of a train the trainers, this is what we want mediators to be doing around the country. And it is on us as advocates and those of us at the Resource Center to get this information out. So as we talked a little bit about earlier, we know that mediation is a rapidly growing field. We also know that there's very little consistency or regulation in the field. Some mediators are attorneys, like myself. Some mediators are mental health professionals, like Janice. And really, a mediator can be just about anybody who decides to take a 40-hour basic mediation course. So not all states require mediators to take any course at all, and many don't regulate mediators in any meaningful way. Even if you have a dedicated and hardworking mediator, though, mediator styles can vary considerably from one jurisdiction to another and even within programs. So some programs use mediators in what's called facilitative mediation, and that's where mediators really don't take any opinion, don't weigh the case at all, don't make any suggestions. Other programs employ an evaluative mediator model where they treat mediation a little bit more like a settlement conference, usually run by judges, where the mediator might actually weigh the arguments on either side and give the parties a sense of how strong or weak their case is. In the chat box, someone mentioned earlier that there's a third option, and certainly in some counties in California and perhaps elsewhere that use they're called recommending counties, and that's where the mediators actually make a recommendation to the court on what the custody arrangement or parenting plan should look like if the parents are not able to reach an agreement. So with all of this inconsistency nationally and even within programs, it's hard to say exactly what every mediator is going to do. But when we think about what we want every mediator to do, regardless of the program, these are the things that come to mind. So absolutely, first and foremost, because we know that domestic violence is present in over half of disputed custody cases, mediators should really be screening every single case for domestic violence. The screening should be done individually with each party before the mediation begins, and the screening should be ongoing throughout the life of the case. So I've had cases where domestic violence was identified, but where both parties wanted to proceed with joint mediation, and then an hour into the mediation, I realized that the power imbalance was absolutely destroying the mediation process, that it was not safe for the survivor emotionally, if not potentially physically, and I had to make the call that at that point, even though it felt appropriate to begin the mediation, it was no longer appropriate to proceed. And so that screening doesn't stop the minute that the parties walk into the room. It needs to continue throughout the life of the case. And there are a number of different screening protocols available. Some of them will be listed in our publication for mediators that comes out, and you can always reach out to us at the Resource Center for technical assistance or more information on this. So turning to the second, mediators really do agree that mediation is best when the parties want to be there. Nevertheless, many court mediation programs are mandatory unless an exemption is requested or granted, and some programs don't allow for exemptions at all. But even if you're in a mandatory program, mediation needs to be voluntary. And for it to be voluntary, mediators need to adequately inform the parties about what the process entails and what the risks are in cases involving family violence. Because without being well informed, it's not possible to make a voluntary decision to participate in mediation. It's also important that mediators do a really thorough job of explaining confidentiality to every client that walks into the room. In most programs, mediators are what are called mandatory reporters, as are many of you, and so they have to report any statement or information that they receive about the neglect or abuse of a child or an elder, or a statement that a party intends to harm themselves or somebody else. It's really important to know what your local statute says and whether information about children witnessing domestic violence is reportable as child abuse, and whether information that is shared in a mediation would then require report to child welfare by that mediator. So it's incumbent on the mediator to explain what their duty of confidentiality is and what any limitations to that confidentiality are. And in those recommending counties where the mediator then changes their hat and makes a recommendation to the court, it's equally important that they explain that role really thoroughly so that participants know what will be done with the information that they share and whether it can be shared with the court in the form of a recommendation or a report or any other way. Somebody mentioned, or a number of you chose earlier in the multiple choice, decide whether it's appropriate to mediate. Absolutely. So after appropriate screening, mediators need to think long and hard about whether it's appropriate to mediate cases involving domestic violence. And this looks not only at whether it will be physically safe to do so, but also whether there's a pattern of coercion and control that will impact the party's ability to negotiate freely and openly, since the nature of the abuse may not lend itself to collaboration required for successful mediation. If the mediator does decide that it's appropriate to go forward with the mediation, they should really think about offering shuttle mediation or telephonic mediation. In shuttle mediation, the parties are not in the same room, so unlike joint mediation where they sit together, which Janice talked about earlier, shuttle mediation has the parties in different rooms with the mediator moving back and forth between them. So this can help prevent batterers from using nonverbal means of threats or control that may be invisible to the mediator, but of course it can't eliminate it completely. So another, perhaps even better option is that of telephonic mediation, where the parties appear by telephone and they're not even required to be in the same building. So mediators are supposed to be neutral third parties. So this means that they're not supposed to take a position or give their opinion about the case or the parties. Even if mediators are attorneys like myself, they really shouldn't be giving legal advice or taking sides with either parent. And they shouldn't be making any final decisions about the custody agreements. The parties do, and if they're not able to, then the court does. When we were preparing for this mediation, Janice told me that she used to tell parties that she was neutral about the case, but not neutral about safety. And I really love that way of looking at cases involving family violence, because mediators, especially in court programs, are really working as officers of the court. And so in this role, it's incumbent on the mediator to make sure that the parties don't enter into agreements that jeopardize the safety of the survivor or of the children. And I noticed in the chat box that someone else noted that mediators shouldn't let their emotional impact get in the way of the case, and that's absolutely true. If they have biases or feelings about a particular case or about domestic violence, then they're not able to maintain neutrality, and they really should not be on that case. So although many programs include domestic violence as part of their training, the quality of the training can vary widely, and some programs don't train at all on domestic violence. As we've mentioned throughout, a mediator that doesn't understand domestic violence simply cannot understand how it will affect the mediation process and won't know how to keep the parties safe. They also won't recognize common batterer tactics or survivor behaviors, and that may be misinterpreted, sort of like what we talked about with Carissa and Dawn. If you think back to that, I can absolutely imagine a scenario where a mediator perceives Carissa as inflexible, and where that could then be used against her in mediation, and that's really problematic because protective parenting is often misconstrued. So caucus is a tool that is available to mediators and that they can use to check in with the parties. So I've had parties where there is identified domestic violence tell me that they want to be together in the same room. If they feel safe and I feel that it's appropriate, then I will let them do that. But regardless, I will caucus with them frequently and regularly just to check in to make sure that it is still appropriate, that both parties still feel that they are able to speak openly and freely and without fear of coercion or reprisal, and certainly I will caucus before any final agreement is reached to make sure that everyone is comfortable with it. One of the big things that I've noticed in my own practice is that it's really important for mediators to understand that success is not defined by reaching an agreement. And that's hard because a lot of programs out there define success as agreement rates. And so if a mediator knows that their success in their program is being evaluated based on how many successful agreements they reach, it makes it difficult for them to realize that in certain cases, especially those involving domestic violence, success may simply mean realizing that consensual agreement is not possible, that the process is no longer safe, or that this is really a case that should be left for a judge to decide. And when a mediator reaches that decision, either to not mediate or to terminate the mediation in the middle of it, it's really important that the mediator terminate it in a way that doesn't jeopardize the safety of any of the parties. So when I do that, I take responsibility for declining to mediate or terminating. And I say, you know, based on what I'm seeing, I just don't really think that this is a really good case for resolution and mediation. It seems that it's premature, or there might be some things that would be best to let a judge decide. But I will never say, you know, one of the parties told me that they no longer feel safe and therefore we're not going to proceed with mediation. It's really important that the mediator take responsibility for that decision and keep all of the parties safe. If the mediator does decide, so one of the other things that we do in our program that I think is really great is we offer a cool down period. And in our program we offer a 2-week period. The parties don't even sign a parenting plan at the end of the mediation, and what they do is they have 2 weeks to review it, perhaps go over it with an attorney or an advocate and talk about whether they still feel comfortable with it. If they don't, they file an objection, and that's all we tell the court, that an agreement was reached, an objection was filed, and there is no parenting plan. We don't tell the court who it was that filed the objection, and again, we take responsibility for it. So we keep that information all confidential, again, to protect the parties. But I think that that's really, really important to have something like this in cases involving domestic violence, because it allows survivors a chance to back out of an agreement if they feel that they were coerced or bullied into it. So the last bullet we have here is never mediate whether the abuse occurred or the terms of a protection order. These are really matters that need to be left to the court to decide. These are not matters that are open to negotiation or discussion. And so these are areas that should be decided by the court and should not be a part of custody mediation. And I don't think that there are many custody mediation programs through courts that allow this, but this is sort of out there just for folks that are talking to and educating private mediators so that they understand that these are not areas that should ever be part of a custody mediation. But as we've said throughout, many mediators don't understand domestic violence. They may not have received any training or adequate training, so these may not be automatic. So we're going to talk a little bit about how you as advocates can help make sure that your clients have these positive experiences.
And Melissa, before we do the poll, I want to back up to the previous slide quickly and just highlight a couple of pieces. It is much more frequent now for protective orders to contain parenting plan terms. So it can get very tricky when you have a restraining order or a protective order that has domestic violence related protections embedded and also parenting time or even custody embedded in the temporary order. And so what we found in the jurisdictions where I worked is it could become very difficult to walk this fine line between mediating the protective terms of the order and mediating something like safe exchange, which is in some ways absolutely a protective clause, right, because it's to protect the survivor from being targeted while exchanging kids, but it's often part of a parenting time arrangement. So it's just a highlight of something to sort of be mindful of when you're looking at this concept of not negotiating the terms of the protective order. Sometimes there's protective language embedded in the parenting plan. Okay, so.
And Janice, I see a couple of questions. Can I just answer those quickly?
Yeah.
So I see one saying, who makes the decision about ending the mediation for safety reasons? The mediator makes that call. Certainly, if a survivor tells me that he or she is not comfortable proceeding with the mediation, then I will not proceed with the mediation. But it is my call to make. But again, I take responsibility for it so that I don't jeopardize that person's safety. But that is on the mediator, because part of mediation is ensuring a safe environment. And so it's incumbent on the mediator not to proceed if it's not a safe environment. And that's part of it is educating mediators that they should be making that call. And then there's another that says I've heard mediators say things like they're in an investigatory role or it's their role to ferret out the truth. I would disagree with that role. Mediators are not custody evaluators, and mediators are not sitting as judges. And in fact, when I sit as a mediator and I explain my role to the parties, I say that I wear a different hat where I sit as a pro tem judge, and in that judge, I have to hear evidence and decide what I believe is the truth or most true. But as a mediator, that's not my role. I'm not here to hear evidence. I'm here to provide a process to help you reach an agreement on your own. So I would encourage them to sort of reevaluate what their role as a mediator is. And Janice, I don't know if you want to add anything to that.
No, I totally agree. Related to both questions, the other person who really can end the mediation is obviously one of the participants. And one of the things that we talked about in our program when we oriented people to the process, we always made sure people understood how they could end mediation if they no longer felt safe. And really, we offered that to both participants in the room, regardless of the story. This is how you can end this process. It was very important to us that people knew how to finish mediation and not feel like they were captives to the process.
And one way that I do that, one way that I do that in my orientation is I'll say, when I do an individual orientation, I'll say if there comes a point that you are not feeling comfortable, that you need a break, you can either just ask me for a break, or sometimes I'll give them, a woman that I mediate with gave me this tip, and I love it. She hands each of them a pen beforehand, and she says, if you're feeling uncomfortable, you can pick up the pen and start sort of, moving it around, and that'll give me an idea that you need a break, and we can check in and caucus and see if we should proceed. So there are really innovative, creative ways that mediators can communicate with the parties to make sure that they feel safe throughout the mediation. And I would encourage them to find their own way that works for them so that the parties can terminate the mediation if they want to.
And to your second point, Melissa, if a mediator is saying it's their job to ferret out the truth, that is really not how mediation is intended to operate. Now, if they're saying that in a state where they happen to have recommending mediation, that may be a different story, but I would say that the vast majority of mediators would not agree that the ferreting out of truth is an appropriate role for a mediator. It is actually really the opposite of that. It is holding the notion that both persons' perspectives are true from their perspective and honoring that and holding a safe space for people to have a different view of the situation and negotiate from that lane. So that position is really not consistent with generally how mediation is thought of. So we are on another poll. This is a question about how you as an advocate can help Carissa prepare for her custody mediation. And it looks like some people have responded. And I don't know, Alicia, if this poll allows people to select more than one option. So we may have the same dilemma here.
It doesn't. So if you want multiple responses, just let us know in the chat box.
We'll give people a few more seconds to respond. And it looks like overwhelmingly people are noting that all of the above may be the best answer in this particular case. Can we minimize the poll? Thank you. So how can you as an advocate help Carissa prepare? One is sort of obviously your general role as an advocacy community, and that is building relationships with the mediator community and offering training on domestic violence. And I really want to put in a plug for offering training on post-separation violence. This was the area where I really saw a lack of adequate training and information for mediators and other folks who encounter people after divorce. So often the training is focused on the dynamics of the relationship while people are still together. And what we know is that often some of the worst violence, the most disturbing battering tactics, the most distressing things for children are things that happen after the survivor tries to leave the relationship, and sometimes for years after. And often courts and court harassment can come into play as a post-separation domestic violence tactic that gets employed. So really critical to train your local mediators on what does domestic violence look like after someone has made the very difficult decision to leave. Developing a safety plan with Carissa. So as a mediator, I certainly had conversations with domestic violence survivors about their safety and safety planning, but in a neutral role, I had to do that very carefully, and I could not visit that topic at the level that I think an advocate can. And so often I was sending domestic violence survivors back to their support persons, whether that be an advocate, a legal aid attorney, a family member, who really helped them think through how can they safely enter into a negotiation process with this other person. So really working with the survivor on how to develop a pre, during, and post-mediation safety plan, because things can come up in mediation that can elevate risk again, and having that conversation in advance is really important. I think we already talked about this, initiating a collaborative relationship with your local custody mediation program, really working on trying to understand the lens they are applying to looking at conflict. What you hope for is a lens that says, wow, a lot of these contested cases have these kinds of difficult issues presenting, like substance use disorders, domestic violence, sometimes child abuse and neglect. All of those things can manifest in contested cases. That's often why they're contested. And a mediation program that can articulate that they're observing that is often really ready to have these conversations about how to protect survivors in the process. But building those relationships will help you know your mediation community and have a deeper understanding of their level of sophistication around these subjects, and then build relationships so that you might be seen as a resource and a place for training. Educating Carissa on her legal options, always a sticky issue, but to the degree you can provide information about your local jurisdiction, you can be very helpful. Many DV programs have some legal resources associated, and hopefully those legal folks have a good understanding of local domestic relations law, mediation rules, and things of that nature. It's really important. What I often found is that domestic violence survivors would come to the table in mediation and say, of course the court is not going to allow this person to have contact with my children. And it was really important that they understood that that was absolutely a possibility. And so preparing for mediation is really about the number of different scenarios that can occur and how to negotiate based on what are the realities of your local court rules around contact. And that goes hand in hand with preparing Carissa for custody mediation. So helping them understand the philosophy of mediation, the intent of mediation, know something about their local mediation program. In our county, we prepared a flyer. One side of it said, hey, here are all the things you should know about mediation. Here's how to prepare. Here's where you come. This is how we do it. These are some of the general concepts. The other side of it was literally an entire page devoted to deciding whether or not it was a safe option for you. So it addressed all of the things we did to check in with people about their safety in the process. So helping her prepare for custody mediation, helping her know what questions to ask. Specifically, advocates can help survivors develop safety plans to share with the mediators that include lots of things like, and I'm going to refer back to screening, before you even walk in the door, asking the mediator whether or not they screen for violence, whether or not they account for violence in their process. So that's something I'd want to know before I even did any of these steps. It is certainly appropriate to talk with the mediator about your safety concerns and ask to sit in a certain place in the room. Many of my survivors really wanted to have a table in between them and the other parent. That made them feel safer, just a little bit of a physical barrier. And they wanted to either sit near me on some occasions, or they wanted to sit near the door. Some of them really wanted the abuser to sit near the door because they knew that if the person became escalated and had an exit, they might be less likely to become aggressive. So having that conversation with the mediator is important. Requesting staggered arrival times and departure times, and that's really critical. Many people ask people to show up at separate times, but they don't have strict guidelines around who's showing up when. So generally speaking, it's best practice for the domestic violence offender to show up before the survivor so that you know that person's whereabouts. I would often text or call the survivor to say the other parent has arrived, you can come to the building now, and to allow the survivor to leave first so that the phenomenon of what I call parking lot harassment or intimidation is less likely to occur. So we made it very clear when there was domestic violence identified to the person who had offended that the expectation was that they stay 10 minutes and allow the other parent to leave. And if they were not willing to commit to that, we would not proceed with mediation. Asking the mediator to use caucus frequently and before any final decisions are made. So caucus is just this sort of mediator term for having separate conversations with each parent or participant in the process as a way to check in about the level of safety and comfort with the decision-making process. It's absolutely appropriate to ask to participate by phone. If a mediation program can't accommodate that, that may be a flag that they're not really well-versed in dealing with domestic violence and mediation, because any program that knows this subject well has accounted for ways to mediate with people not physically in the building. Asking the mediator to provide separate rooms for waiting for mediation to begin or for taking breaks is really critical. We were able to accommodate that because we had 2 entries in our program, but that can be a really good way for someone to feel safe. Some mediation programs don't allow an advocate or an attorney in the mediation, but if that advocate is in the separate waiting area, that can be a very helpful sort of touch point of safety for a survivor if he or she needs to take a break and check in. What else can you recommend that a survivor do to increase safety? Asking the mediator to set ground rules. Mediators in general often will talk about some ground rules for the process. They'll say things like, let's try to stay away from history, let's try to focus on the present and the problem solving going forward. They may say some things about an expectation that people speak respectfully with each other. They may talk about things like pointing or name calling or glaring. It really depends on the program. I have certainly been aware of programs that allowed people to scream and yell at each other. They felt that was just a natural part of the process. We did not allow that in our program. We felt it was important to tell people that we expected respectful behavior and that we were going to enforce that. Ask to have the mediation happen in a safe place if it's possible. Our mediation programs, both of the programs I was in were in courthouses, so we had the great good fortune of having metal detectors and sheriff's deputies on site in the building. We had a panic alarm in our office suite. So we had lots of ways to reassure survivors that they could enter the building safely and not come to harm. Ask the survivor, ask the mediation program if they're willing to allow the survivor to bring an advocate or an attorney or support person. Sometimes the mediator is comfortable with them sitting in the room, sometimes they're not. And then again, really helping survivors get access to legal resources of some kind that help them understand what the general rules, guidelines, and expectations are in their community. Is there a presumption against custody when there's been domestic violence? What are the rules in that mediation program around having to disclose domestic abuse if a child was present? Those kinds of things. I want to pause for just a second because there are a number of questions that I am looking at here on the feed. It appears that they relate mostly to training, so I will let Melissa cover that more as we wrap up, if that's okay. Additionally, helping survivors prepare, many jurisdictions still have standard parenting time plans that often become a sort of default. A lot of places have gotten away from that because they've wanted to support parent choice and creativity, but busy courts are often willing to default to standard language, and it doesn't often account for domestic violence. very, very important to help survivors prepare in advance. As you all know from working with survivors, being in the presence or even being reminded of events that surround the abuse by the other parent can be very activating and very triggering for a survivor. And the thinking part of their brain may feel less accessible. So if they've had some time in advance of mediation to really think through what they need to focus on and what they hope the outcome will be, it's really helpful for them. Bringing a support person, we have talked about. Don't encourage them to bring a support person who is likely to escalate conflict. I found aunts, uncles, advocates, grandmas, amazingly wonderful support people, and new boyfriends and new girlfriends were typically not particularly helpful. So that may not rise to a level of a rule, but I can tell you that when I talked with survivors on the phone and they talked with who they wanted to bring to mediation, I would really have them think about what was likely to put them in the least danger and be the least activating for the other parent and create the most safety for them. Someone calming, someone supportive, someone who understands how to handle these situations. Real basic stuff like bringing copies of work schedules and school calendars. Again, they can be nice, cognitively anchoring tools that someone can look at when they want to disengage from a difficult conversation, and they also can help guide the conversation around facts and information and less emotional subjects. Focusing on what's best for kids is obviously important, and understanding that a mediated agreement doesn't modify a court order in and of itself. In most places, an agreement is simply an agreement, and until it's actually signed by a judge into order, it is not necessarily enforceable. And that's really critical when there are even temporary orders, such as domestic violence restraining orders. We often had parents who had agreed to some terms that would be different than what was reflected in their domestic violence restraining order, and we had to develop a process that allowed the survivor to request that the court modify the order in order to incorporate the parenting time terms they'd agreed to. Otherwise, it can end up backfiring on the survivor because it can look like the survivor is now not, quote, following the order, and that has sometimes been used against them later in other court proceedings. So we were very careful to say, this is great, this is an agreement, there are some next steps you would have to take to actually have this change the terms of your existing order, and we help provide them with some tools to help them understand how to do that. And Melissa, back to you.
Okay. So one of the things that has sort of surprised me in my practice as a custody mediator is that many times, I would say almost always, the parties come in really not having a good understanding of what custody mediation is in and of itself, but also what their custody arrangement or parenting plan means. And this is obviously more often true when they're self-represented litigants, but sometimes it's also true when they have counsel. And so what I found when working on our publication, thinking about what would be most helpful to self-represented litigants, was I think they really need just a very basic explanation of the topics that are generally covered at custody mediation. And so our SRL guide that's going to be coming out actually has descriptions of each of these topics. But I think as advocates working with survivors, preparing them for going into custody mediation, or really any custody case at any level, it's important to have a basic understanding of the law. And so while you maybe can't give them legal advice, you can perhaps give them legal definitions, or at least once it comes out our publication. So here are the main topics that are generally discussed in custody mediation are legal and physical custody. So legal custody really refers to which parent has the right to make the important long-term decisions about the children. So not the day-to-day decisions, but big decisions like where the children will go to school, what religious instruction they'll receive, if any, and how big medical decisions will be made. So think big picture decisions about the children. And so legal custody can come in different ways. You often see it as joint legal custody, even if the children live primarily with one parent or the other. Courts will often still grant the parents equal authority to make those big decisions about the children. In some jurisdictions, there's a presumption against joint legal or physical custody where domestic violence is present. So it's really important to know what your jurisdiction says about these things so that you can properly advise, or an attorney can properly advise them before they walk into mediation. So physical custody is the other sort of hot topic, which is also really, it talks about the day-to-day, right? Who do the children live with? Where do they sleep? And which parent makes the day-to-day parenting decisions? So when kids spend about half of their time with each parent, usually between 40 and 60%, it doesn't have to be exact, and that will vary depending on your jurisdiction, it's usually referred to as joint physical custody. When one parent has the children most of the time, in our jurisdiction it's over 60% of the time, that parent is said to have primary physical custody. And a third and really less common alternative is sole physical custody, and that's where they're exclusively with one parent. The reason it's so important for folks to understand these concepts before they walk into mediation is that I have had parents come into mediation where the court granted sole physical and legal custody to the survivor parent, and then ordered them to custody mediation, and in mediation the other parent was seeking joint custody. And I, as an attorney, was in a difficult position where I could not advise the parents on their legal rights, but where I felt that it was incredibly unlikely that the judge was going to change that plan to joint custody. And so it's really important that survivors and parties, all parties, understand what the local laws say, and if there are any presumptions in place that may act to their benefit in a courtroom before they inadvertently perhaps give up some of their legal rights. And so if you are wondering what your local court statutes or rules say, this is certainly the type of information we can provide at the Resource Center. We can't give legal advice for a particular case, but we can absolutely help you look up what the law says in your jurisdiction and your cases and whether there are presumptions in place. So you can reach out to us if you're interested in more information on that. Parenting time used to be called visitation. It's mostly called parenting time, and that talks about the amount of time that the children spend with the non-custodial parent, so the time that they're visiting with the other parent. Exchange is really how will the kids be transferred from one parent to the other. This is really important in cases involving domestic violence because it can increase risk of harm during exchanges. So sometimes survivors will want to set up exchanges at a public place, sometimes in front of a police station or at a library or even at a safe exchange center. A supervised visitation center will sometimes do exchanges. So those are things that you want to make sure they think about before walking into mediation. Custody mediation will often talk about holiday schedules, birthdays, vacation, basically who will the kids spend each of these with. In cases involving domestic violence, it's really important that these be outlined very specifically. What time will the kids be exchanged? Where will they be exchanged? Who will be responsible for bringing them? If transportation is required, who will be responsible for paying for that transportation? The more detail that goes into that parenting plan at the onset, the less room there is for coercion and control down the road. Other topics that are often discussed include child care. Who's going to take care of the children? So if a party wants a grandmother to watch the children, it's really helpful to ask the grandmother if she's available before walking into the mediation so that the mediation isn't stalled on a term that really could have been explored before walking into mediation. But most folks walk in not knowing that these are going to be the topics covered, and so it's not their fault, but with proper preparation, they can really come prepared. So right of first refusal is a really tricky area. that is often covered in custody agreements and in custody mediation. And this refers to an agreement between the parents that one parent will give the other parent the option of caring for the children before they enlist a third party for care. So before calling a babysitter or putting them into some sort of child care program. It's really important to think about whether this type of provision makes sense. Sometimes if there are step-parents involved or boyfriends or girlfriends that are living in that parent's home, it doesn't make sense to give the other parent the right of first refusal, particularly if that's going to increase the amount of contact and perhaps escalate things. But some of these boilerplate templates, parenting plans that courts programs are still using, have this language in there automatically. And so it's really important to educate survivors to look for this language, make sure it doesn't find its way into a parenting plan without them understanding it and agreeing to it. Because it can be a really slippery slope that they can head down if they're agreeing that every time something comes up that's unexpected, they're going to call the other parent and let them have the right to see the kids. So extracurricular activities, discipline, any plans to relocate if they know they're going to move out of state and they're already thinking about it, those are terms that could potentially be discussed at mediation. And same with plans to remarry. If one of the parents knows that they're going to remarry, it might not make sense to put a right of first refusal in there if they know that there's going to be someone at home that can care for the children or whatever other considerations that may bring up. So finally, we have information exchange, and I saw somebody in the chat box had just written about how do the parents communicate with one another, and that's what this information exchange is really about. If parents have a joint physical or legal custody arrangement, or even if there is parenting time or visitation, parents are going to have to communicate about the children. And this can be a really tricky area for cases involving coercion and control or violence. And so it's really helpful when folks arrive at mediation and have put some thought into what works and what doesn't work. Sometimes it's okay for them to agree to only text one another about the children. Sometimes that works. Sometimes that opens up communication to continued coercion, control, abuse, and it's just not safe. So it really depends on the parties. It depends on what they're comfortable with and what works for them. They can communicate by telephone, email, text, or there are a number of really sort of amazing new app-based programs out there that parents can sign up for and that monitor the communication. And that monitoring can be shared with the court, so it's not, you don't have to track texts and emails in quite the same way. It makes it much easier so that if there is any abuse during information exchange, that can easily be shared with the court. I've heard through my clients that come through mediation that they really like using these programs, that they've made it possible for them to communicate without escalating into violence or creating an unsafe or uncomfortable situation. So I would say, take a look at those different app-based programs. I know different courts will actually order parents to sign up for certain programs. And from what I can tell, those have been really useful where folks feel like that would be helpful. So we keep coming back to this because I really think this is where it all begins. I think that it's really, really important that mediators become well-trained and savvy on domestic violence and how it impacts child custody mediation. So if you're at a coalition or at a local program that has the capacity to provide training, I would strongly encourage you to reach out and offer training to your local mediation program and or reach out to us at the council because, again, we can offer tailored training. We can prepare webinars like this, and they can be, on a national level like this one, or they can be for specific groups. And we can also, in certain cases, come out to jurisdictions and train. So this is where it is all really going to begin. I think mediation has grown really quickly, and folks are starting to realize that we need more collaboration between the domestic violence providers and mediators, just like we've learned in all of the other areas. I do see it changing. We're trying to create publications and resources that will be helpful. We do provide technical assistance and training at the Resource Center, so please reach out to us and let us know if there's any way that we can help, because this is where we can make change. So we have exactly 2 minutes. We have been answering questions as we go, but if in the next 2 minutes there are any pressing questions that you'd like to pose to us, please do so. And if we didn't get to yours, or if you'd like to email us later, you can certainly do that. My email is at the bottom of the screen. Feel free to send me any questions, and I or Janice and I will get back to you. And we're so grateful for you all joining today.
All right, as we're letting people just type in any last-minute questions, I just want to let you know that anyone who would like a certificate of attendance for today, you will be directed to an evaluation following the webinar, and just fill that out. And at the very bottom, there is a place where you can request a certificate, so that's your avenue to do that. I'm just going to give you a couple of minutes to keep typing. I think we're looking good. I did see a couple of questions come in about future training, so we will reach out to you individually. I know we didn't touch on that, but we'll reach out to you about those questions. We do not provide CLEs directly. I see a question about that, but if you do need a certificate of attendance, then you can follow the link to the evaluation for that.
So I see a couple asking to email the presentation. We can certainly do that. And also, if you look in your materials box, you should be able to download it right now if you have the capacity to do that.
All right, we're at the end. Thank you all for joining. I do see a couple questions about the recording. You'll all get an email with the recording.